So like Josue said, at the beginning of the year, there was a lot of changes that they've been overshadowed with COVID rules. So I want to make sure that you guys understand what happened at the beginning of the year, because that will play a role moving forward in the next 10 years, because what happened at the beginning of the year will be in place for the next 10 years. Now, January 2020, new rent control was applied throughout the whole state of California. So that's what you're looking at here initially. So that is Assembly Bill 1482. So as of the beginning of the year, we now have to obey by rules and regulations. Now, there are some few exemptions to those regulations, and those exempted properties are units that were built in the last 15 years, B, single family residences and condos, so as long as they're not owned by an LLC or a corp. Now, I know that the law says that you could be an LLC or a corp so as long as an individual owns the unit. But before COVID, and we filed a couple of evictions that were single family dwellings owned by an LLC, those cases became really expensive as far as litigation wise, because a defense attorney will grab onto anything to make a case, right? So that, if you're an LLC or a corp, your eviction is going to cost more, because now you have a defense attorney forcing you to prove that you don't own other LLCs and declare, your financials and whatnot. So stay away from that. If you are purchasing new properties and there are tenants in the unit and you do want to evict the tenants, now once you clear the property from the tenants and you do what you want to do or you need to do, then you could transfer your property into an LLC. Now, C, owner-occupied duplexes. So if a property is occupied by its landlord and he's renting the other unit, those are also exempt from rent control rules. And also we're gonna add ADUs to that, and the same rule applies. The owner has to live in one of them. Now, a lot of people are not familiar with what rent control is, which that's gonna change soon, since we now have it throughout the state of California. But rent control pretty much is the state telling us how, and by us, I mean the property owner, why you could evict the tenant, when you could evict the tenant, how much rent you could increase, and what rules you have to follow year after year. Now, if your property is exempt, you could forget about the government telling you what you could and could not do with your property. You're free and clear to do what you want. And this is why a lot of investors do buy old homes and knock them down and build new, because those properties are not subject to rent control rules. Okay, now moving on to Assembly Bill 1110, which was also enacted at the beginning of the year, and that has to do with rent increases. So the rent increase period has changed. Now, if a landlord wants to increase the rent for more than 10%, a 95-day notice applies. If a landlord wants to increase the rent for less than 10%, a 35-day notice applies. And I'm gonna repeat, I know I'm probably gonna sound very repetitive, I just wanna make sure it lands. This information is statewide, but your local governing law still supersedes state law. So if your local city is saying you cannot increase the rent, then we cannot increase the rent. If your local city is saying you could do it 3%, then we could do it 3%. So the information I'm giving you is throughout the state, but if your area has their own rules, we have to follow those rules. If your area does not have their own rules, then we have to follow a state rules.
So Paulina, and there's a handful of areas in our backyard that do have their own rent control ordinances. For instance, we can call on City of LA and County Unincorporated LA that limit to very minimal amounts. in those cases, even though they're under 10%, it still has to be, so there's no more 30-day notice anymore. Are you incorporating now so it's going to be 35-day regardless of what the jurisdiction is?
Right. So unless your local area says that you require additional time. But normally rent increases, timeframes are regulated by state. We really haven't seen the local government step in to that regard. The local government steps in more for relocation money, for just cost types of reasons. But yeah, good point. Now, local city ordinance. This year has been the first year that so many new cities decided to adopt their own rules towards landlords. If I'm not mistaken, I want to say this year alone, 37 different cities in California added their own set of rules. And this is just to give you an idea how unfortunately, when clients come in, they tell me, Paulina, all I need to know is if I could do this. I'm like, I cannot answer that. We need to do a full-on case analysis because so many laws may apply. We could have in LA City, one area when there's 5 different homes right next to each other, and they all have different rules and regulations because a lot of things come into play. Who owns the property? How many units are there on the lot? When was the year built? So it's kind of like when a client calls realtors and they ask you, could I buy a house? You have no idea. You need to get them pre-qualified. So unfortunately, now in this new era of evictions, when people ask me, could I evict? I cannot answer that without doing a full case analysis. And I like to preface that just so you could really get an idea of what we're dealing with here in our eviction world. Okay, so now I'm really gonna move on to COVID, landlording, the new landlording during this moratorium period. So from the beginning of the halt, which happened in the middle of March, we've had rules after rules after rules, and they seem to be changing every month. But as of right now, the next set of rules are going to be in place until February 1st. So this is the information you kind of want to master until then. After February, you're probably going to have to learn a whole new set of rules. But okay, on September 1st, the Judicial Council, and the Judicial Council is the body who governs what the California court system could and could not do. They expired the halt, which means they are now allowing lockouts to resume. They're allowing pending cases that were waiting in court to proceed, whether it's with the default, whether it's with the court hearing. Now those are going to be moving forward. And any new qualifying eviction may get filed in court. Now, we have this state of California new layer of rules, which is a Tenant Protection Act known as Assembly Bill 3088. So this bill has placed a mask protection towards all renters. And let me rephrase that, it's not all renters, it's residential renters. Residential renters in California. Now, this protection will be in place until January 31st, 2021, and it covers a back rent from March 1st through January. Now, in essence, and this is going to be a heartburn. Trust me, I cried and had a heartburn when I heard this news. Rents will be non-evictable during this period, unless, and there's a very little unless, right? If the tenant is completely non-responsive to the landlord's notices. Now, notice how I have on my screen 15-day notice. Welcome to COVID period. It's no longer 3-day. It's going to be a 15-day until the end of February. In February, we might get new laws or we may not. If we don't, then we're gonna go back to normal, which is rules prior to COVID. Now, this protection is saying that the small claims is gonna have to deal with rents. And that the local laws supersede. So if your local law says that you cannot start collecting rent until 1.5 years, we have to follow local law. So I'm gonna move on to this breakdown. So I have 3 different breakdowns because that's what we're dealing with the most right now. We have rents prior to COVID, which is before March 2020. And we do have renters that owe rents prior to. So if the rent is due prior to March 1st, we could still do a 3-day because that was the law during that time frame. After a 3-day, if the tenant does not pay, we may pursue an eviction because that was the law during COVID, prior to COVID. Now, if your tenant moved out and they owed you rents prior to March, you could proceed with an eviction, with the small claims against them, okay? Now we go with phase 1.
So
phase
Paulina,
1,
real
yes.
quickly, so in this situation, someone owes, for example, January, February, we're preparing a 3-day notice, but we're only including that period. They may have not paid anything afterwards, but we're in this case, probably the only time we'll get a 3-day notice ever again is we're only including the time up until February 29th, right? Like we're not preparing a notice, anything beyond, at least for this case, what you're talking about in this first little bracket.
Correct. So we're just talking about that little bracket. So we're gonna be, let's say the renters owe you rents on all these levels. We're gonna have to have 3 different processes going on. Okay? All right, so phase 1, I'm sorry. And phase 1 is what Assembly Bill is calling for the rent from March through August. So from March through August, if the rent is due, you are supposed to issue, or you're not supposed to, you have to, issue 15-day notice by tomorrow, along with the disclosures and the AB 3088 information. So whether or not your tenant is gonna pay you, if you don't send out these disclosures, we may not be able to pursue later on the collection of these rents. I know, mind blowing, but that's once again, California law for you. This is why it's so imperative to send out those declarations ASAP. If the tenant does not answer within 15 days, and it's they're not consecutive days, it's working days only. And let me clarify that because some of us work every day. It's court days. Then we may proceed with an eviction for breach, not for rents, for breach. Now the chances of winning that eviction, I see that depending on the area, I see that a little low. If it's LA, chances are they're not gonna give us a win. If it's another county, chances are we will. It really comes down to each county because each county is either very conservative or very liberal. Now, if tenant does answer and says, oh, here is my declaration, I'm still affected, I'm not working, and unfortunately the threshold for that response is very low. All they have to do is self-certify, and that is good enough. If they self-certify, then we could pursue for rent after March 1st in a small claims action. Now, small claims judges are gonna start to hear cases for non-payment of rent until March of 2025. So they're opening this for 2 years, and there's no cap. So normally it's 10,000. Well, if your tenant owes you 13,000, you're still gonna be okay with, if the tenant owes you 50,000, you're still gonna be okay in small claims. Now, small claims judges are gonna have a department just for rent-related cases, and they're gonna be trained to identify if the landlord followed the law. So if the landlord followed the law, you will get a judgment that says that your tenant needs to pay you back this money. Okay, now moving on to phase 2. Phase 2 is rents owed from now, September 1st through January 31st, 2021. So the law says on that the deadline for that is February 1st. The landlords must issue a 15-day notice by February 1st. And the tenant must pay 25% of the debt owed within the 15-day notice. If the tenant does not pay the 25% of what they owe, then you could file an eviction. If the tenant does pay you 25%, then the balance needs to be worked at or requested in small claims. Okay, my last disclosure here, that if your tenants speak a different language, the disclosures must be translated into their language.
And all these rules, these are all statewide, independent of whatever's happening at the local jurisdiction. I mean, that disclosure needs to go out to everybody.
Right. Actually, all this information in this page is all statewide.
Mm-hmm. And so how do you deliver notice?
That is a good question. I was not going to get to that. No, I'm just because I have so much other information right now. It is okay, Adeline. I'm taking questions at the end. I'm sorry. Josue is helping narrate, but I'll take all your questions after.
We have this all scripted already.
Yes.
So just bear with us.
So Josue, the way you take you serve notice is personally deliver. You have to go and knock, and if the tenant is there, you can give it to them. You could not give it to someone under 18. It has to be over 18. If no one's home, you can leave it out the door and you could send it by mail. We always recommend to do it by delivery confirmation and certificate of mailing, both ways, which is a white slip and the green slip. Okay, now I'm gonna move on with the information because we're getting a lot of questions on the chat and I wanna make sure we have time for the questions. So this is just reading material that I'm showing on this slide. If you want a copy of this, once again, email my team. Do not send me your email here because once the meeting is over, I will not have access to your email. And you could email my team. I'm putting that information now to emptyevictions@gmail.com. Let them know that you want copies of the webinar material and we will get it out to you. Now, allowable evictions, what could we do? So right now, what we could do is our notices of termination that expired prior to March 1st, those may resume at this point. We may evict for landlord occupancy, so as long as there's a purchase contract. So if there's a purchase contract, because a buyer is gonna move into a property, we may start that eviction except in LA City. LA City is not allowing us just yet. We are gonna know after the end of October when LA City is gonna start allowing that. Now, breach of lease or contract. So let's say your tenant is breaching the lease. If you don't have a lease, they're not breaching a lease. So technically we cannot evict. So make sure we know that. If we don't have a lease in place, there's no breach. And if the breach has been in place for more than 4 months, it's no longer a breach. It is implied by California law that the landlord was okay with the breach, thereby is part of the new agreement. Okay, once again, I repeat, I know I'm getting private messages for the information. Please email my team. Don't email me here because I will not get to every email by the time this webinar is done. So I will repost our email so you could multitask and send it to my office and our office will work on that. Gmail, let me do that once again so you can have it here. Okay. Now we could evict for a governmental order, and we're actually getting a couple of those. Police departments are issuing a lot of governmental orders and public health and safety and illegal activity. So if you have any of those reasons, those evictions.
Is yours freeze also?
Yeah, she froze.
Okay. So while she's doing that, maybe I can kind of jump in here. She was talking about governmental orders, and we honestly don't see a whole lot of that stuff. I think the main ones are going to be the first part of these allowable evictions. So we've started to move on a couple people, and obviously for me, it's not an ideal situation to evict a person. It's very time consuming, and but you know, we've in certain cases we have had to move where the tenant has owed for quite a few months, and obviously if they've owed since February, well, the chances are they haven't paid since then. Let's see what else we have here. I think we lost her completely. All right.
I'm so sorry, my computer just decided to take a break from me.
I'm glad I have a copy of the paper PowerPoint next to me, because I was just going to start going into it, but we're good.
Oh, good. Perfect. Thank you.
All right.
Oh, all right. That was a scare. So moving on with to-dos. So landlord, you must be in communication in writing. Text messages does not count, so please stay away from text messaging. Also, if you have not done all the notices that you have to do throughout the pandemic, those are imperative. Now, we are suggesting landlords to attempt their own payment plans or a buyout. This is a perfect time for a buyout. Lucky enough, California has not frozen buyouts. Buyouts have been frozen in other states, but not in our state. So we could make an agreement with the tenant to waive some of the rent in exchange for them to move out. And that, if we, as realtors, we know that that is gold, because then the property is worth more, or the landlord could do whatever they want with it, or they could list it as a empty unit. Now, if you also need to issue monthly courtesy reminders of the running balance. You have to have all your paperwork up to date and in compliance. That means your rental agreements. Rental agreements were supposed to be updated by September 1st of 2020. If your rental agreement is not updated, if the COVID letters haven't been issued, if certain things haven't been done, our evictions are not going to get approved, or the small claims request for the money. So it is important, landlord, this is where I'm telling you that not being up to date will cost you money financially. So those landlords that unfortunately they don't have access to this information, or they don't want to pay a professional to get their portfolios, or their tenant portfolios reviewed, and they're behind, they're gonna lose a lot more money than what we're already losing. And because I lost the chat, Josue, I have no questions on the chat. So if you could get to the questions, that would be great.
Sure. Yeah, we can start to go through some of these things. And so Paulina, as I start to scroll up, she hits on a good point. You know, a lot of this stuff, we try to prepare notices on our own. We try to, well, first of all, most of our brokers don't allow us to manage properties, but a lot of things we try to do on our own. And I'm a big believer in creating niches. You know, a lot of people sell multifamily, they sell, you know, they go into little farms or whatever it is. And this is, I think, where an opportunity where you can rely on the expertise of someone like Paulina's team to help you guys with that stuff. Because she actually does prepare and help prepare notices and review lease agreements and whatnot. On our end, obviously, we do the management of properties. But all right, I'm at the top now. So, well, there's a few people asking for your slides, and so there's one here regarding 3 units, Huntington Park, 1 tenant refuses to pay, has not paid since June, has been a nightmare. I understand that. Not sure if they can even start the eviction now. My lights just turned off because they're on. There we go.
Yeah, and the name for that individual?
I see Robles. Robles, I'm going to ask to unmute you if you're still there.
Okay. I'm gonna close my chat since I can't see.
Hello.
All right.
Hello.
Hi. So it's actually I'm here on behalf of my dad. So it's his properties. He's having issues, and they want to know, I guess, if it's worth starting an eviction. I just saw the 15-day notice, so we're definitely gonna have to get in contact with you.
Yeah, unfortunately, like I said, California is making it really hard for us to evict. So we have to try to do A, B, C, D, E, and all the way through Z in order to make sure that you have your ability to evict. Now, chances are, if this tenant does not respond and ignores all your letters, then we're gonna have a chance. If the tenant does respond saying, hey, I'm sorry, but I'm still not working, that's good enough not to evict him under the eyes of California law. So we will have to wait until after March to proceed with an actual small claims against him.
Oh, okay. Yeah, they're.
If you don't do the documents that you're supposed to do, we're not going to have the authority to continue legally to go after that money. So it's very important that we get that going.
Okay.
Okay, so you could email our team. Right now, we're completely booked almost like for the rest of the week. We've been working, I was telling Josue, we're working till 9 p.m. all of us last night. We're trying to supply the demand. So bear with us. We will get you in and we'll do your paperwork.
Okay, thank you.
Thank you.
All right. The next one's from Esther. Esther, so I'm going to unmute you soon. It looks like the first one, if they can still evict, can you evict if someone's on a payment plan? I think is her question.
Yes, no. So, Esther, what city?
City of Long Beach.
City of Long Beach. How many units on the lot?
So it is 6 units total.
Okay, so you're under Long Beach law ordinance. That's going to expire by tomorrow, and then we're going to go under AB law in that area. With that said, we have to do the 15-day notice. We need to do the whole protocol. After that, it depends on the tenant's response. And it's going to pretty much be similar to the answer I just gave Ms. Robles.
Okay, so as long as they respond and they show that they have like no money or proof of funds or anything, we can't evict.
Right. But if you don't send out your notices, you're not going to be able to collect on that rent from March through August. So
what are the exact notices again?
It is like, it's a bundle of 3 different notices consisting of a 15-day notice. Depending if the property qualifies for the CARES Act or not is the type of notice. So if the property qualifies for the CARES Act, it's actually a 30-day notice, still passed under the 15. If the property does not qualify for the CARES Act, it's a 15-day. And then along with the addendum for the AB 3088 rules, along with the addendum of the AB 1482 rules, and along with the financial disclosure for COVID. So what we're doing is we're selling the whole bundle, including your consultation appointment, for $295, and that will include the second set of notices that we're gonna have to do in a couple of months.
Okay, and then can we raise the rent on 1 unit, not the other units?
Yes, I don't recommend, well, it depends. If it's been more than a year, yes.
Okay, so it's only been 6 months, and
So you can't, you could only do it once a year.
because it's only a 6-month lease though, and now it's month to month.
You could only do it once a year.
And if the garage is not part of the lease, we can raise the rent on the garage?
Oh, you could only raise rents in California for any rent controlled properties, and this property is controlled by AB 1482 of 1 time per year, regardless of what it is. So it is 1 time per year, Esther.
Okay, thank you.
Okay? Sorry, I wish I had a different answer, but then I would be lying.
That's okay, but they can, people can raise the rent though, once a year.
Yeah, depending. So like I just explained at the beginning of this, it's all layered law, and we have to We really have to be careful and compartmentalize. My broken English comes out all the time, okay, guys?
Oh,
So
no, it's
bear with
okay. Thanks.
So
depending on the section of law is the type of rules we have to follow.
There is different agreements though, and so a lot of times the lease agreement, and there's all sorts of different lease agreements that address parking and garage or whatever it is, but there are a handful of agreements that, for instance, depending on the jurisdiction, we separate parking. We separate whether it's garage or, because that is independent on that. So I don't know if that's the case with Esther, but yeah. We'll go on to the next one. I got Kathy Castillo, client looking to buy 2 units. Can he increase the rent by 10% to the tenant that was already in the unit?
So every question you guys ask me means nothing if I don't know the area, how many units on the lot, and when the property was built. So Kathy, please unmute yourself so I could answer your question.
Okay, sorry about that.
So Kathy, what city?
LA. It's on 62nd and Figueroa.
Give me a zip code, please.
90044.
So your unincorporated area borderline, do you know if you follow the bills get paid to Edison or DWP?
I think it was DWP.
Okay, so if you think it's DWP, then that's LA City rules. And LA City rules, we're under a rent freeze for 1.5 years.
Oh, okay.
Okay?
I have another question because he's been there for 4 years, basically. His lease expired last month at the beginning of September.
Okay,
So,
I'm listening. I'm just
okay.
multitasking. I do this all the time, but I'm listening.
Okay, so the lease is expired and we've been talking to him. He's about to agree on a cash for keys agreement.
Beautiful.
What can we do? Is there like a different paperwork that we need to file?
You do not do, so there's 3 things you don't do on your own, and Josue loves this one too. So you don't do your own taxes, you don't do your own plastic surgery, and you don't do your own legal paperwork.
Okay.
So do not do your own legal paperwork. You could contact us, or you could contact any professional office that knows what they're doing along with evictions.
Oh, okay.
Okay, thank you,
I'll
Kathy.
be giving you a call. Thank you.
So I only have 15 minutes left, Josue, so let's just, let me see, I have no access to the chat room.
Right. There's one regarding access, and I don't know if we need to bring her on, but it says, what if the property has a gate and the tenants keep it locked? And so this is regarding proof of service, I imagine, or delivering of a
Perfect,
notice.
so I love these. This is common area. If it's common area, you could knock it off, you could open it, you could change the locks, you could do whatever you want, so as long as it's common area. If you're talking about it's somebody's home, they're locked to get into their home, you could do it with a 24-hour notice of change of keys that you need. They have 24 hours to give you a copy of the key, or that you will change the locks, and of course you give them a copy of the lock. Okay?
So there's current tenant hasn't paid rent for 4 years. Oh my God. Oh.
So
Okay.
I see that one. Analia.
Okay.
Hi. I'm gonna be mad at you, not the tenant. The tenant is riding the free ride. Okay, Analia, we could evict because it's rents out prior to COVID. I will just have a couple of questions to make sure that we could, but just at a glance, it looks like we could proceed.
So you have access to the rest of them, but Adeline, so there's no lease in place. It expired, but well, this says
So
in
technically,
February.
Adeline, if there's no lease in place, then nothing expired anywhere. So it comes down to what area is the property located in. So
Southgate.
These questions do not help me without
The home is in Southgate.
How many units on the lot?
Just one. It's a single family home.
Single family dwelling, LA County, unincorporated LA County, Southgate. Right now, we're not going to be able to serve 60-day notices in that area until after October 31st. So starting November 1st, we can.
regardless of whether they have a breach of contract, non-payment, or no lease?
Good question. No, it would have to be for a just cause. So it would have to be because a landlord wants to move into the property. It has to be under AB 1482 law, because until February 1st, the protections of AB 1482 have spread into non-rent control properties. After February 1st, it will not matter the whys. Before February 1st, it matters the whys. So if you have a single family dwelling in an area where you could serve notices, then we need a reason. Is it because the landlord needs to move in? Is it because there's a breach, so on and so forth? But if there's no lease in place,
But you said there's no
technically
breach if there's no lease, right?
Correct.
Yeah, there's
That
no
is
lease.
correct.
Okay.
So you want to get
One
you
more
wanna
question.
get an
As far as the
agreement in
bundle,
writing.
as far as the bundle that needs to be sent out by tomorrow, is that something that your team will be able to have time to get all those
I
taken care
cannot
of?
promise that we're gonna have it on time, just because we are working at a max speed to, how many do we have, 300? We have 300 to finish by today, and we have another 200 by tomorrow. So we will try, because I'm leaving out of town and I'm still working from where I'm at. So we're gonna try, but I cannot promise a 100%, because I don't like to promise when I can't deliver. But we will definitely try. Okay. Now the next question, Edwin. Hi, Edwin. I love Edwin. Well, he's my regular client. Okay, Edwin. If a tenant found to be subleasing the garage or a room, is that violation of the cost for eviction right away? Compton single family dwelling, built 2005. You know the drill. Yes, you could proceed on a 60-day notice. Now, my question is there a rental agreement?
It was a lease that got expired last year.
But there is an agreement in place. Perfect.
Yeah.
So when there's an agreement in place, it doesn't matter that it expired 10 years ago,
Right.
the same terms and conditions continue. So the same terms and conditions may be enforced. So it does not matter that you don't renew the lease. What matters is that you don't lose the lease. So as long as you don't lose the lease, what we're gonna have to do is make sure that you did your AB 1482. Without the AB 1482, we cannot do anything. Okay, so email my team the lease and what you have, and then I'll take a look at how we could proceed, okay?
Everybody, I appreciate it.
Thank you, Edwin. Next one is Joanna, purchased last week with a 3-month to 3-month agreement triplex in Southgate. How much could we raise the rents? So Southgate, it's a triplex. You could do 5% plus current CPI. Current CPI in that area is 0.69%. So your total increase for this will be 5.69%, and it has to be done with a notice of new ownership. Without a notice of new ownership, you don't have legal authority to increase the rents or collect rents. Also, you do a notice of new ownership, rent increase, and if possible, new rental agreement. If you do not want new rental agreements, the AB 1482 must be issued. So it's also a bundle of notices. So I hope that answered your question, Joanna.
Thank you.
Not a problem. Ana Lidia, we are booked for today, but email our team and we could see when's the next available appointment. I'll let you know right now.
I think
Okay, we have an
Maryland's,
available
yeah.
appointment Wednesday at 10 a.m. So you could go ahead and email my team,
I
please.
see one from Maryland. It's very similar to Edwin's question, single family, garage converted.
Okay, no, so Maryland, if you're gonna do a garage conversion, we don't mix a 15-day. The 15-day will be a separate issue, because a 15-day of the it's less of a chance to evict. It's more to collect your rent in the future than to evict. Now, Vilma, can you list the forms that you need to be served by tomorrow? I could do that here. quickly is the declaration under AB 3088, and it's another declaration under 1482 and 15-day, depending if it's CARES Act or not, is the type of notice, and is a financial disclosure. Okay, all right. Now, okay, I think we're done with the questions, and I finished right on time.
I think you're going to have a lot of phone calls coming in the next hour or so.
Yes.
But
All right.
yeah, so that was, obviously this is a lot of stuff. It's very heavy. I do recommend you guys email her office, get the report or get the slides, review them. Definitely don't, your broker is going to tell you don't give legal information unless you are an attorney yourself, right? But definitely leverage the resources that the Downey Association offers you guys, the partnerships that are available. Ton of information, but again, reach out to Paulina's office, make sure that she's working till 9:30, 10 o'clock every night, at least until September.
No, I don't answer phones after 5. I'm sorry. I have to finish your work. Thank you, Edwin.
Yeah, but thank you guys for joining us. Yeah, absolutely.
For helping, and thank you, Downey Board. Could we get a hi from the Downey Board? I know Janet is there.
Janet's, yeah, she's on there. Joey, Kayla, they're all, I saw them all on there. But
It's
thank
our
you guys
pleasure.
for your time.
Thank
And,
you for
we'll see you soon.
allowing me to host to your group.
Thank you so much. We appreciate all the information that you gave our members. I mean, it's more than enough.
That was a lot.
Thank you, team.
But yeah,
And
okay.
thank you, Josue.
Absolutely. Everybody, have a great day.
All right.